who is the director of the county's public defender offices, who's going to give you a visualization or picture of what happens to an offender once they've been arrested and have to go through the system. Great.
Thanks, Jim. Nobody said anything about it being warm and letting a lawyer talk. Thank you. First of all, let me explain to most of you something that you won't know, and that is in Oregon, public defenders' offices are private nonprofit law firms. We contract with the state to do the work. But in most states, public defenders are city or county employees. Here, I'm the director of a local nonprofit. One of my board members, Ron Chase, is here with us this morning. So the title of this talk, if it needs a title, might be called The Unsatisfying Anatomy of a Criminal Case. So a case begins when a citizen reports a crime to an agency such as Chief Prince's, and the police go out and investigate. Sometimes that investigation is instant. Sometimes it takes time with detective work. But at some point, the anatomy of a criminal case begins when the police make an arrest and charge a suspect with what the police think the law is the person has violated. The case then goes, if it's a felony case, to the district attorney's office. The lawyers at the district attorney's office review the police reports, review the law, and see if in fact that the charges that the police arrested the person on are the correct charges for the case. Most of the time, those charges will match. Sometimes the district attorney's office will raise or lower or change the charges. That triggers a court date for the person who's been arrested. So if a person is in jail, that happens within 48 hours. If a person is not in jail, it happens generally in several weeks. We are appointed, our office is appointed at the court date. The court staff verify the financial wherewithal of the defendant, and if the defendant is poor enough, roughly think about what it takes to qualify for food stamps. If a person is indigent to that level, then they are granted a court-appointed attorney. My office takes most of, about 70% of the cases in Lane County Circuit Court. There's a consortia of lawyers who take the rest of the cases where my office has some sort of conflict of interest. We have about 45 people on staff at my office, about half of whom are lawyers. I think right now we're one lawyer down and running about 21 lawyers. So after we're appointed on a case, the next thing that happens is we get the police reports, what we call discovery, from the district attorney's office, and that can take from days to weeks depending on the complexity of the investigation and depending on whether the local police agencies have given all of their reports to the district attorney's office in a timely manner. Agencies like Eugene and Springfield Police, state police, which are pretty efficiently run organizations, the district attorneys and us don't wait on those police reports very much. Some of the smaller police departments who are a little less adept at shuffling paper, the wait can be longer. So then we contact our client. Let's say the client was in jail and got released, like many are being, as the chief said. It's not as easy as your doctor calling you to say, let's remind you about that appointment. We mailed you the letter. Because most of us, when we get the little postcard from the doctor, we respond. We're responsible. Most of us in this room are professional, educated people. We know how to keep a calendar. That does not describe our client population very well. So our clients are mostly young males. I think the data shows that 15 to 39 are the ages of criminal activity. Many of our clients have learning disabilities. Many of our clients have drug and alcohol problems. Many of our clients have mental health issues. Many of our clients have a short attention span. Many of our clients get to be our clients because they have poor impulse control. So we're talking about trying to affect good communication with a population that is not skilled in that. And so our ability to contact clients and get them into the office is hampered by that at times. And sometimes we are not given the time before the next court date to visit with the client, to set our investigators loose on the case and do our work if we haven't been able to access our client. Many of our clients are homeless. living on the couch circuit or at the mission or something like that. So we get hold of the client, and the first thing we do is we tell the client not to talk to anybody about the case. That includes telling the client not to apologize to anybody if they've harmed somebody and they express remorse to us. We tell them, no, don't do that. That there will be a time for that, but that time is not now. So we're losing the first opportunity there is for remorse to be expressed, because it would be poor lawyering to have clients who have not yet been convicted of anything apologize for things they've been accused of doing. I don't think that's a tough concept. So we get in the way of any remorse being expressed early on. Once the apology does come, which it often does come later on in court, and often whether or not it's genuine and whether or not the client expressed the remorse early on, it's often viewed as canned and lawyer-prepped apology, and quite honestly, sometimes that may be true. So we investigate the case. That can take some time. Criminal cases all end in one of several ways. Either the district attorney dismisses the case outright because they're convinced it shouldn't have been a case to start with. Some cases go to trial, where people may be found guilty or not guilty by a jury of their peers. The vast majority of the cases are plea bargained or negotiated, or there's some settlement worked out between the parties where maybe some charges are dropped, or maybe there's some sentencing concessions made about whether a person goes to prison or not, or if they are going to prison for how long. But the vast majority of the cases, when I say vast majority, I'm talking in the 90s percent-wise, come to some sort of resolution. Ultimately, of course, the client makes a decision. Our job is to work the case, prepare it for trial, then let the client know what it looks like, and let the client know what the risks are and what the rewards are, and the client needs to make that ultimate decision. Sometimes we find ourselves in trial when it's not our judgment that that's the best option. Nonetheless, it's the client's case, not our case, and we always need to be mindful of that. Typical case lasts for several months. So what we've done is we've taken a young man with poor impulse control and a short attention span and maybe these other issues, and we've taken weeks and months to do what in their view could have been done in a few hours or a couple days. Our clients get very frustrated by the way the system works. The average 19-year-old doesn't understand that things take weeks and months in the real world to happen. That's not the way their brain functions. There's people smarter than me who can explain the why of that. I just know the fact of that. So we've taken somebody who might have had some genuine remorse right after they did whatever they did, and we've frustrated them and we alienated them, and we've taught them that people in suits are not their friends, and that people who have been to college too much are not their friends. And so we've alienated them from our system as it exists. In the meantime, we're unable to, in the current environment, we're unable to refer them to the treatment they need before the end of the case. There is some treatment available for court-ordered treatment. So when a judge orders somebody to go to anger management or drug and alcohol counseling, the two most prevalent forms of treatment that people get ordered to, there is some treatment that exists in this community for those folks. But there is virtually nothing available for people who have issues who don't have money. So if you need inpatient drug and alcohol counseling in this community and you don't have money, you get put on a very long waiting list. The one exception might be if you're a pregnant woman. But what used to be in this community was somewhat better than it is today. When resources shrink, as the chief was talking about, the resource shrinkage with the recession and all that, treatment gets cut first. Treatment gets cut first. Jail beds get preserved before treatment gets preserved. We can argue about the right or the wrong of that. I may have a different impression of that issue than some friends of mine, including the chief, but the fact of the matter is that's the truth of the matter. And so there is nowhere. We used to be able to send our clients to treatment before a judge ordered them to go to treatment, because that would, one, help them stop reoffending, so that when maybe we had a client who had one case who stayed with one burglary case, and we, by the time we got to court, would be able to get a probationary sentence and keep that person in the community. Now, with the revolving door, they're not being held in jail. We don't have a treatment vet for them, so they continue their drug activity. They continue doing the crime they need to support that drug habit. And by the time we finally get them stopped, they've accumulated a handful of cases, and under some of the minimum sentencing laws in Oregon, that property offender, non-violent, just a property offender, has now accumulated enough thefts, ID thefts, forgeries, burglaries, and they're going straight to a prison bed, which costs us a lot of money as taxpayers. So by the time we get to the end of the case, whatever motivation the client may have had to change their behavior or make amends for their conduct is sometimes gone. We've alienated it right out of it. And for those who don't get sent to prison, they've lost a lot of the motivation that would have made them successful in treatment. So the court can order people to treatment, but of course there's no judge who has the power to make somebody succeed if they don't have the will to succeed. And so we have people coming back on probation violations and going to prison later in the case rather than earlier in the case because they flunked their probation. It's very frustrating for those of us who work in the public defender's office. Sometimes we're perceived as trying to help guilty people get away with crime, and maybe that happens from time to time, but for the most part, the lawyers in my office are dedicated, hardworking people who want to help clients succeed. We don't want clients to keep coming back. And as a system, as a society, we would all be better off with less recidivism. I mean, the whole deal of the police and the courts and the lawyers and the social workers, the whole point of this thing is to reduce recidivism and make the communities safer. And we're not doing a very good job of that. I know others will speak to the victims' experience of frustration and alienation with the criminal justice system. That's not my role here today, but I will point out that when we don't treat people with drug and alcohol addictions and when we don't treat people with mental illness, we cannot expect them to go out, seek and maintain employment, and pay restitution owing to a victim. That's just an unreasonable expectation, and the rates of payment prove me out. So we've alienated a young person that we should have been able to help. Our mainstream culture has alienated them completely, but there's a culture that hasn't alienated them, and that is the street culture or the prison culture of crime. And our clients know each other in prison. They get to know each other better. They do not come out of prison smarter than they went in. They do not come out of prison having had less conversations about great crime schemes than when they went in. And the Department of Corrections, until recently in Oregon, was a very good place for people to get treatment in prison. The recession and the state budget have caused the Department of Corrections to have to cut a lot of that in-prison treatment, as well as some of the incentives for people to engage in that treatment in prison. So the work that was done with inmates in prison until the recession was considerably better than what we're doing today. And I'm not faulting the Department of Corrections. I think it's been a well-run organization. It's just the budget realities that we have put upon them. So that's my cheery talk about the unsatisfactory anatomy of a criminal case. I think there's some better news following my talk. Thank you.